Hello and welcome to Billing and Collecting in Financial Forensics. Today we're going to review some best practices. My name is Elizabeth Woodward. I am with Dean Dorton Allen Ford. We are a full-service accounting firm in Kentucky. We have offices in Lexington and Louisville. Some issues in financial forensics cannot be avoided in terms of it taking us longer to collect than some of our tax and audit colleagues. For example, I do a decent amount of work in bankruptcy court, and so pursuant to the bankruptcy code, I can only seek payment every 120 days. But outside of bankruptcy court, there are some other issues that are unique to forensics, and for those, we need to identify risk and develop good habits to try to minimize risk to our firms. So first, let's consider what makes forensic billing riskier than other forms of accounting. Obviously, we are often working in the midst of emotional matters, so for example, a divorce. Some of our clients, even if they are high wealth, they may not have dealt with accountants before or dealt very much with accountants before. So even though they have the money to pay our invoices, they're just not accustomed to paying for this type of service. To the extent we work with corporate clients, in-house counsel is often under budget pressure. They budget annually what they think fees are going to be, and then if they have an unexpected matter, they're going to be under pressure. So we need to be aware of those and be aware of their budget cycle. Also, I know we encounter regional differences in rates. So for example, if I am working with an attorney from Chicago or New York, my Kentucky rate is a good deal. If I am working with a client where rates are lower, then our rates seem high to them, and that can all affect their thoughts on our invoices and their speed of paying them. In terms of some engagement level best practices for you to follow, think about billing and collecting out of the gate. So if the first referral call is from the attorney, get an understanding of that attorney's experience and collection experience with this client. From the initial discussions, get the facts of the case. Make sure you understand so you can estimate the scope. And I like to prepare budgets for clients. Now, you always need to understand those might be discoverable. And also in forensics, since each engagement is different, it's difficult for us to estimate with certainty what things are going to cost. I have found that if I try to do phases, so phase one will include these steps and will get us to this point, it's easier for me to estimate under those parameters, and it seems to make the client more comfortable. I usually give ranges. So for example, phase one will be between $10,000 and $15,000, which may seem like a big range, but obviously depending on the engagement, that might be as close as we can get it. At the beginning and throughout the entire project, you always need to think about the cost benefit and make sure you talk honestly with your client about that. They may want to know, for example, how their spouse was spending money, but it may not make economic sense for you to perform the work, the forensic work, to come up with those answers. Engagement letters, talk with the attorney about who the engagement letter is going to be between. A lot of attorneys want it to be just with them. They may think that privilege will apply or attach if that's the case. So just understand that. You may want to consider having the ultimate client sign it at the bottom, just acknowledging it so that they understand the fee. I always send my engagement letter, I date it as of the date I'm sending it out, and I would expect the attorney and the client to sign it accordingly with the date. I don't want a backdate situation. But if I've already done some work, I will just put in that first paragraph, this letter is effective as of, and then that should cover privilege if it attaches. In the engagement letter, I include information on the retainer if I'm going to request one. I include what my hourly rates are. Sometimes we do a blended rate if it is an engagement where I'm going to be able to leverage to lower hourly rates. A blended rate might make sense to me and might make the client more comfortable. You should include detail on how you're going to bill. So in my case, that's monthly, and the invoices due within 30 days. I also do charge interest on late invoices. I include in there a right to withdrawal if I'm not paid. In terms of best practices for collection, you should bill often and send statements. We list unpaid amounts on the bottom of each invoice to make it clear if multiple invoices are due. And it is a good idea to collect any unpaid amounts before you testify, either at deposition or at trial. Certainly, if you're walking into a deposition or trial and have not been paid, you need to make sure that the attorney is aware of that, because you will get questions on it. Don't avoid picking up the phone and calling quickly if something's past due. It might identify a service issue. If you're at the end of an engagement, you might consider a payment plan. You might consider a signed note if the full amount due is known. Keep in mind always that emails and voicemails regarding collections are discoverable. And it's a good idea for you to understand your insurance company's opinion on you suing clients to collect. If you are in a divorce engagement, and you are working for the non-breadwinning spouse, you should have open conversations about that with the attorney, and perhaps the attorney can go to the court and ask that the breadwinner give a sizable retainer to you and the attorney. So, unfortunately, that brings us to the end of our allotted video time for today. So I hope that you have enjoyed this video and find it useful to your practice.